This video explains what happens when you go to court to talk about a crime that happened to you. If it's hard for you to communicate with people who don't know you, you may need someone to help with communication. For example, if you use sign language, you may need a sign language interpreter. Or if you speak with or use a communication board or device, you may want help from someone you know and trust. Sometimes the police and court may want you to use a person called a communication intermediary. They will hire this person to help you communicate with them. This is because they want to be sure communication between you and police or the courts is correct and your exact words, not someone else's words. A witness is a person who can give information about a crime in court. The witness promises to tell the truth. You'll be a witness if the crime that happened to you goes to court. You'll get a letter called a subpoena that tells you when to come to court to testify, which means to tell your information to the court. It will also tell you the name of the Crown Counsel lawyer who is asking you to testify. It's important that you go to the court on that day and at that time. You must go to court to testify if you get a subpoena. If you don't, you could get a fine or even go to jail. The law says all employers must let their employees take time off work to go to court if they get a subpoena, but they don't have to pay you for the time away from work. Some of the expenses you may have from being a witness, like transportation or childcare, may be paid back to you. Talk to the Crown Counsel who sent you the subpoena. You can bring someone with you for support and to help you communicate with the lawyer if you need it. This person can be a friend, translator, communication intermediary, or a victim services worker. Talk with the Crown Counsel about what will happen at the trial and what you'll be asked to do. Most courts in Canada have victim witness assistance programs that can answer your questions about how a trial works and give you support. The Victim Assistance Program can support you while you do a victim impact statement. You can learn about this statement in another video. They can go with you to court and provide other support. Go over the details of the crime. Call or ask a support person to call the Crown Counsel office or a Victim Assistance Program office to check the date, time, and the place you need to go to be a witness. If you use a wheelchair or a scooter, ask if the courthouse is accessible. Think about transportation or childcare ahead of time to make sure you're at the courthouse when you're needed. Courthouses don't have childcare, but you may be paid back later for childcare you needed to have to go to court. If you, your support person, or your communication intermediary made notes about the crime, ask your lawyer if you can bring them with you. Bring all of the documents that were talked about in the subpoena. Bring your notes, if it's allowed. Get to court early and be ready to wait for your turn. It can sometimes be a long wait before you're called into the courtroom. When you're a witness, you're not allowed to listen to the other witnesses before you testify. You might be able to stay in the courtroom after you give your testimony. You may have to wait outside the courtroom or even come back on another day to finish your testimony. The judge or Crown Counsel will let you know. Someone will tell you when it's your turn. This person will walk you to the courtroom. The court clerk will ask you to take an oath to affirm or promise to tell the truth. If the judge says it's okay, your support person, communication intermediary, or translator will be there to help you. You'll be asked to say your first and last name and to spell your last name. Then you'll give your testimony, which usually has 3 parts. The Crown Counsel will ask you questions, the defense lawyer will ask you questions, and the Crown Counsel will sometimes ask you more questions. You have a right to give testimony and hear testimony in ways that you understand. It's okay to ask for a break if you're confused or upset. If you don't understand a question, ask the lawyer to repeat it or explain it, or let the communication intermediary know and they'll help you. Think about each question before you answer. Give an honest and full answer. Try not to use words like I think or I guess, but it's okay to say I don't know or I don't remember. Only tell the court what you're sure you saw or heard yourself, not what someone else told you. It's important to always tell the truth when you testify. If you don't, you can be fined or even go to jail. Yes, you have to answer all of the questions from both lawyers. If the judge thinks a question is wrong to ask, he or she will tell you that you don't need to answer. It's hard to know how long a trial will last. There are many reasons that can cause trials to last a long time. All witnesses, except some children and some adults, must testify in court when the accused, that's the person who's been charged with the crime, is in court. If testifying with the accused in the courtroom feels too hard, talk to your victim services worker or the Crown Counsel about this. Remember that many steps have been taken for the safety of everyone in the courtroom. You can also bring someone with you to court, so you'll feel safer. Some changes in the way you testify can be made if the Crown Counsel thinks you're a vulnerable adult, which means someone who has some special needs. Your victim services worker or the Crown Counsel will tell you if this applies to you. If they don't talk with you about this, ask them.